Joyce, it's good to see you, my friend. Let's start with that 1 a.m. ruling. I'm happy to see the SCOTUS works at 1 a.m. on a Friday night, but it's a temporary pause, number one. Number two, Joyce, it only pertains to the, quote, putative class of detainees. Explain to our viewers what that means when it's just a putative class of detainees.
Right. It's such a confusing situation. There's been an effort by the ACLU, which represents many of these detainees, to certify a class so that rather than going person by person to seek relief, they can do it all in one big grouping. The Supreme Court put a little bit of a monkey wrench into that when they ordered that these had to be individualized habeas cases. And that's why there's this back and forth with the ACLU trying to play whack-a-mole, going to court literally in every district where they get wind that something is amiss, which is what happened yesterday when they learned that ICE appeared to be putting detainees together so that they could deport them from the Bluebonnet facility in Texas in a different district in Texas from the one district where a judge had entered an injunction prohibiting further deportations. In a way, the Supreme Court's chickens are coming home to roost here. They're having to deal with these midnight petitions because instead of a nationwide ban on these deportations, while they decide the extent of the Alien Enemies Act and whether the government can use it for these deportations, they're now having to do it in all 94 federal districts.
Joyce, what happens, though, with the fact that the Fifth Circuit, which is the federal appellate circuit between SCOTUS and this district court in Texas, the Fifth Circuit, with a panel of three and a per curiam, actually said we don't have subject matter jurisdiction, and so they didn't give a stay themselves to the plaintiffs that are kind of fighting it out in the district court in front of that judge.
Well, that's right, and this will be fought in a number of different forums. The ACLU has indicated that they intend to bring, in essence, try to certify a class in each of the 94 federal districts. So there's this possibility of different rulings in different places. Ultimately, the Supreme Court will have to decide the Alien Enemies Act issue for once and for all. But until then, we're going to see a variety of different procedural motions in different circuits, in different district courts. And it's something of a mess while people's lives and futures are at stake.
Joyce, I've always kind of let our viewers in on a little secret. You and I are good friends, and we talk a lot about the law in our free time that you don't have a lot of because you're such a busy person. But let's talk about this birthright citizenship oral arguments thing that's coming up on May 15th. A lot of people think that the substantive issue of whether or not birthright citizenship is still going to be protected as it is in the Constitution, that's going to be at play on May 15th. But explain to our viewers why that's not going to be the issue, why it's really a focus on nationwide injunctions.
Well, thanks for outing me as a legal nerd, Katie. I appreciate that more than I can say. And this is one of the nerdiest of cases because although Donald Trump has an executive order about birthright citizenship, about ending birthright citizenship, that this case emanates from, that's not the issue that the Supreme Court has granted appeal on in this moment. Instead, they're going to consider whether a federal judge sitting in one district can enter an injunction, a stay of future action that can impact the entire country. And look, both Republicans and Democrats have objected to these at different points in time. For instance, Democrats, liberals were against the stay issued by a federal judge in Texas that tried to make medication abortion illegal all across the country. So this is a procedural device used by both sides. Whether or not it's efficacious has long been in question. Now the Supreme Court will decide that for once and for all.
And, you know, finally, Joyce, I have less than a minute left with you, but I did want to ask you, we saw that really profound order from Judge Boasberg when it came to criminal contempt. I know it's kind of been hashed over a little bit during the week, but I do find it to be telling, though, that we have a federal judge who has said, you know what, this is not going to happen on my watch. This is not going to happen in my lifetime as I sit on this bench. People are going to actually abide by court orders. Do you think that resonates in any way up to the Supreme Court, and that's why we see stuff like we did this morning?
You know, I think it really does. Judge Boasberg's order about initiating contempt proceedings has now been stayed, but he's not the only judge who's in this position. And something that's clear for anyone who's even a casual observer is that the Trump administration is not concerned about what the courts tell them they do or they can't do. They're going to proceed with their policy objections without regard to what the courts say unless and until a court finds a way to stop them. I mean, they are here for the fight. The fight is important to them. This is not about respect for the third branch, the judicial branch. This is about seeing how many inroads they can make into its authority. And the sooner the courts accept that, including the Supreme Court, then the more likely it is that the founders' original intent, that the different branches of government would act as a check on a branch that tries to assume too much power, it's more likely once that realization is there that the courts actually will begin to act as a check.
Joyce Vance, my very good friend, thanks for joining me on the second to last episode. I appreciate it.